of people feel very passionately about these issues. And although you might not be so intimately aware with how many trees are on the Crystal Spring parcel, for instance, you do care about the property in the city of Annapolis, and you want to have your voice heard and factored into some decision making. And the current Forest Conservation Act that we apply in Annapolis does not have any required public input. I'm emphasizing the word required because DNEP has, voluntarily if you will, had some public comment periods on some of these applications. And so there's been some public input, but it's not required, and it's certainly not been standardized. I also use the required as an emphasis because there is an appeal right. And in an appeal of a forest conservation plan, there is a public hearing. But again, I don't think most of us want to wait and to file something in circuit court to appeal to have our voices heard for the first time.
Jared, so on those appeals or those public hearings, are they just letting people vent and not really taking any action on it, just for like?
So far the public input during the process has not been hearings, it has been comment periods.
Right.
So it has been asking, you can go to our website, this is the city's voice, go to our website, provide comments, and then a decision is made. And certain people would say that yes, that input is being considered, and I think there's certain feelings that maybe that input is not being considered,
Okay.
but there has not been hearings.
Okay.
The opportunities for appeal have been very unclear. If you read the David Clymer Phase 2 report, which was just released on the website the other day, if you haven't, I encourage you to go to the city website and get a link for it. It has described how even the best intentioned person who's wanted to challenge this person has basically had to file an appeal after any action's been taken because it's so unclear when you're supposed to file an appeal. And for anyone who's been involved in litigation, you know that if you missed an opportunity to appeal at one point, you can't later on say, I want to appeal, because the court's going to say, no, you missed your chance. So you have to make sure you didn't miss a chance. And so a lot of people have spent a lot of time and money appealing many changes. So hopefully I've made it clear that there have been a lot of problems. I hope I also made it clear that these problems are not just for conservationists. These issues exist for the developers, for investors, for the city staff, administration, for elected officials, and for conservationists. And so there's hopefully enough meetings of the minds that improving all of this is good for all of us. Just as a current snapshot to give you some flavor of what some current forest conservation acts, I highlight some on this page and the next page. And I don't want to spend too much time on it because legislation isn't based on any one or even conglomeration of properties because it's always looking forward thinking, right? So Crystal Spring is certainly a property that falls under Forest Conservation Act, and you can see a quick description. If you look at the very last line there, the forest... Oh, thank you. And is there a way to shrink that? Because we're missing part of this page.
Go backwards? Well, I don't know.
Please don't need to go backwards, right?
Yeah. Shrink it.
Yeah.
Shrink
So it's just the screen isn't showing neither here nor there the whole page. That's okay. I'll work off of that. If someone is an expert at this, feel free to come and play with this while I'm talking. So anyway, Crystal Spring, 111-acre property off of Forest Drive from Hilltop to Spa. If you drive that distance, by the way, if you're coming down from Hilltop to Spa, that's a pretty sizable distance, and that's the short side of the property. It goes back deeper into there, about double the size. Anyway, the last line of that was the forest stand delineation has been, I'm going to say approved because that's what human beings normally would say in the English language. The technical language isn't approved though, so just bear with me. I'm speaking in plain English, not in technical terms. Complete and correct, I think, is the technical term. So the next phase, since they've done the delineation, is the FCP, the Conservation Plan. And that's been what you might have been reading about in the past, basically a year and a half, I think. They've done 3 different FCPs. Each one, the staff has returned for some deficiencies and requests for changes. Most recently, the developers in that particular property have a newest sort of draft FCP that has been in the papers recently, and that's probably going to be their 4th submission. Thank you, Rob. Next property, and again, I want to go through the rest of these a little bit more quickly, just trying to give some flavor of FCA projects. Hayes annexation. There's always name changes with a lot of these properties too, so it's now called the Annapolis Towns at Neal Farm. Smaller property, almost 8 acres. Also, this is a multifamily residential development. By By the way, this information is all off of this website that you can see at the top, Annapolis.gov. If you want to get to the list, follow that. It's spelled out, but it's DNEP spelled out. Click on that, and then once you're there, you'll see FCA projects under review. DNEP has done a very nice job of updating that most recently, and I'm chair of the Environmental Matters Committee. Ross is on the committee too. We ask for an update of this every month, and so they've taken steps to make sure this is posted publicly online for you, because things do change by month. Anyway, on this property, FSD is done and the FCP is approved. Primrose Hill is very close to where we are. That's almost catty-corner across the street. By the way, you're in Ward 5 right now, so welcome to Ward 5. So Primrose Hill is in Ward 5. A little smaller property. Some contention, mostly because of how the city has handled the property, even though it's not as big of a property. Rocky Gorge, another property. Rocky Gorge, I want to highlight, although it's listed here as an FCA project, there's actually no FCA issue pending. They're essentially done with the FCA process. They're more on other issues like road access now.
We eliminated the forest.
But even like the appeals, essentially that case has been closed most recently. Parkside Preserve, formerly known as Reserve at Quiet Waters. This FCP approval is under appeal. The appeal started the other day. Oh, thank you. There we go. Thank you. And then Annapolis Neck is sort of in the preliminary stages. This is down the road past my store by Georgetown Road. I think this is the one that's behind or before the CVS. Actually, there's two properties. The one behind the CVS, this is just before. This Annapolis Neck has been proposed for annexation. And there's other projects. I didn't want to list all of them. I just wanted to try to give a sense of flavor of what properties we're talking about. So what are the issues that has taken 2 years? And actually, give a little bit more history. When Josh Cohen was still mayor, he formed the Forest Conservation Act working group. We have a couple members of that group here, and Diane and Kinsey Potter were there. Ross wasn't on it. Sheila and Ian were on from the city council. A couple developer interests around the council, and they, out of that work, there was a working group draft legislation that was introduced while Josh was mayor. When that term ended, that legislation died because action hadn't been taken on. So when I started this process in the new term, I started from that point with a lot of help from a lot of people to improve that legislation, and that's what started this process. That's what became of O3214. So issues, procedural, DNEP versus planning and zoning. Can we simplify this so that appeals are coming from that the issues are being considered together by the appropriate body and then being appealed together? Planning Commission versus Building Board of Appeals. Who has the expertise who should be considering these issues? And then where will appeals come from? The substantive issues are awfully important. I should also list procedural. I'll list the public input. What kind of public comment period?
Is that the Building Board of Appeals or the regular Board of Appeals?
Building Board of Appeals. So
Between the Planning Commission, because in the past, the Planning Commission has heard developments and Board of Appeals has heard them, and they no longer adhere in the Board of Appeals.
So Building Board of Appeals hears appeals from DNEP decisions. So if DNEP, in whatever that's, like I said, that's separate from forest conservation, but that's something that we've been discussing. Should DNEP be officially the person approving this, or the entity approving this, in which case the appeals goes to Building Board of Appeals. In the draft legislation that is the most current, we have that DNEP is recommending a decision, then that goes to Planning and Zoning to marry up with the site plan, which is what it was supposed to happen, and then Planning and Zoning ties it all together, gives it to the Planning Commission. I'm getting a little ahead of myself, but the idea is that the Planning Commission considers all of the issues.
The appeals board for the...
Exactly. Okay. Anyway, for procedural, I'll also throw in what kind of public input are we going to have? Are we going to have a comment period, some town hall style meetings, which can be somewhat productive, like this sort of format where we could have this sort of exchange? It's not litigious, it's informative. Or is it going to be a more hearing style, which is more of a litigious sort of scenario? Substantive issues, and I'm going to talk more about these in a minute, but just try to highlight what are the issues. No net loss. So just to explain what that means, like I started, Forest Conservation Act envisions that trees will be cut down. It is not trying to say no trees will cut down. a theory that I've been trying to advance, it's modeled after a state policy, is that if you're going to cut down, say, 5 acres here, that somewhere else you should have a gain of 5 acres. And so that net, there's a neutrality there. But of course, existing trees are beneficial for the environment than new trees. No one's going to try to say otherwise. And of course, it takes time for those sapling trees to grow into full-fledged, helpful trees. But again, when we're talking about balance and compromise, having some offset that in 5-10 years will be substantial with certain maintenance agreements versus not having any offset, you can see there's some offset is better than none. And that's mitigation is in that sort of same vein. 24-inch versus 30-inch, that refers to sizes of trees. Right now, the legislation requires the inventory to just identify 30-inch trees and larger. And then for priority is saving 30-inch trees and larger. And we can talk about some of the issues, but essentially, I and Ross and others are trying to push for let's first of all codify that the inventory should at least identify the 24-inch trees and larger. For tree benefit, and we have the trees expert here, I'm not holding myself out to be a tree expert by any stretch, but some trees are actually very helpful in the environment as a 24-inch trees. Some trees are actually really helpful, even if it's a single tree, not in a strand. And so there's a lot of factors that are difficult not difficult, but require some discretion. I did not add it in here, but in procedural should also be that discretion issue. Some people, and tends to be the lawyers among us, for developers and conservationists and for administration, like no discretion. Us lawyers like, here's a limit. You're black or you're white. There's no gray area. And it's either 30 inches is a really nice standard because we can measure that and we have guidelines. But the reality is, and then more of the scientist side of people or the staff side of people need discretion. And so some 24-inch trees are not really helpful because it's non-native or it's not in great shape. And then some 12-inch trees might be really helpful. So that's where you can see, it's one of the things that's been really difficult about this process, frankly, because depending on who's working on it most recently, it tends to favor discretion or no discretion. And so that's been an issue. Forest or trees. So getting to that issue, are trees more helpful together? Are street trees like the trees outside this window as good as the trees back a little further where Milkshake Lane is? Buffers. And so I'm still on the same page, right? Yeah. My page got cut off again, Rob, if you're able to do your magic again. So the next line is 50-foot or 100-foot buffers, and that's referring to how much space, if you say a wetland is really important, and you have a wetland pool right here, or a stream that runs through property is really important, how much space do you need to not have development, to not impact that wetland or stream? The Forest Conservation Act assumes 50 feet is enough. You could read a lot of science and talk to a lot of people in this room that say 100 feet is better. This is another area where set numbers is helpful. 100 feet is pretty clear, right? We all can measure as long as you figure out where you're supposed to measure from. Which is a separate issue. Baltimore, I think it's Baltimore County, has a system where they actually have some grading. So if it's this type of stream, it's 50 feet. If it's this type of stream, it's 75. You can imagine how you can get complicated very quickly. All of these issues you can get complicated very quickly. Fee in lieu. This is something that I really do not like, and so I'm trying to avoid having fee in lieu. The model code and many jurisdictions have what's a fee in lieu provision. Basically, it's saying to the developer, if you're, say, allowed under the code to cut down 10 acres of trees, but you're supposed to replant, say, 5 acres, but there's no obvious place to put it, you can get out of that obligation by paying a set lump of money to the bank or to the city. A lot of jurisdictions have this. I've been told that there are some where it's successful, but the vast majority that I'm aware of, that money is not useful. In Annapolis, it's not useful. The city has done that in other instances. Annapolis doesn't have a whole lot of public places to plant trees. If the city wants to plant trees, where is it going to go? And so I don't like the fee in lieu because it gives an out where I'd rather have, I don't want your money, I want your trees. And if you're going to have no net loss, you're going to have offset someplace else. Variances, for me, is a sort of a side issue, but they tend to be really important. Because say we have a standard that says 24 inches and bigger have to be saved. Well, what that really means is, unless you ask for a variance and get approval to cut down a 24-inch tree or a 25-inch tree and so on. So the variances tend to be sort of a sideline issue because it's kind of at the end, and after a 60-page document, when you get to page 55, you kind of lose interest a little bit. But variances become really important, so we have to make sure we do focus on that as well. And so I depend on some of my experts to help me out with, like I'm looking at you, to make sure we have proper language with variances. What's that?
Who grants variances?
It's basically the same people who would make the underlying decision. And so if it's a planned development, it's a planning commission.
Do they have like ecologists on that commission or environmentalists?
The planning commission is by definition people among us that have certain interest. It is by definition not experts. It could happen to be, but it does not have to be.
Well, I mean, people have environmental interest then.
And so the thinking is that you want basically kind of like a jury. You want the common people, and then to the extent that you have expertise, you bring on your experts. And hopefully the staff is supposed to have provided expertise, and if necessary, they can go beyond staff. The last point on this list is predictability, and this is certainly one of those things that everybody wants. As I started with the various matrices and how appeals can happen, it can get awfully confusing, and there's no place to look in the code to see how it's supposed to work. Everybody wants predictability, both for process and for size of trees and for the substance science. A developer or banker wants to look at a parcel and say, this is what I'm going to be allowed to do on this property before I buy it. Putting the bankers and developers in that position where they say, buy this property, apply, and you'll see what happens, is very expensive. It's time consuming. I have no interest in wasting people's money by any side. I am a business person myself. I think their businesses are necessary. I have no interest in wasting people's money, so I think predictability is very important. Substantive issues. I want to talk a little bit more about, I got to it a little bit already on the last page. No net loss. So I mentioned state policy. If you look in one part of state policy, there's a state policy, not law, mind you, I'm saying policy, where the state is saying we want the state to achieve no net loss. We want to not reduce our forests any further. And I also said that this is a local implementation of a state plan. DNR, Department of Natural Resources, is the state entity responsible for approving the local implementation. So whatever we come up with, DNR has to bless. Yes, you did the right thing. And so far we've had trouble with DNR on this no net loss issue. And it's not a closed issue, but it's been a hurdle, let's say. And so that's been an additional challenge that frankly I did not expect to have. I was expecting Department of Natural Resources, you would think they would say, no net loss makes sense. Great, local jurisdiction wants to do it. Does it cost the state anything to say yes to do it? You would think that would be easy, but so far it hasn't been.
What's their contention or what's their issue?
So in the Forest Conservation Act, there's a chart, and it basically says if you're this kind of use, like say agricultural use, you need to have 50% conservation. In industrial, it's much like 15%. And there's all these numbers attached to that. So after 50%, you're allowed to cut down this much forest, and you need this much mitigation. DNR's statement so far has been that chart is immutable. Everywhere else in the Act, and everything referenced in the Act says the local jurisdictions should treat this as a floor, as a minimum standards, and the local jurisdiction has to meet, or exceed. And so we've had the view that exceeding this means no net loss is better than allowing 20% loss. But so far they've said that chart is as part of state law, is not part of the meets or exceeds. And I can't explain it because I certainly don't agree with it, but that's been the challenge. 24-inch versus 30-inch, what trees are going to be priority? Frankly, ideally, we would not be talking about inches. We would talk about quality of forest and quality of trees, but that's not how the Forest Conservation Act is set up. So I'm not in that ideal world, and I'm not going to try to change the state law. I'm working within the framework we have, where we do have to talk about sizes of trees, hopefully with some discretion. But in an ideal world, that's how we would have quality, not the specifics of size. Trees versus forest we talked about. I talked about the 50-foot versus 100-foot, and I talked about the fee in lieu. When you start to think about what can you do as citizens to help us have a very productive Forest Conservation Act, these are the issues. These are the issues that we're going to end up talking about. It's, number one, get this thing done already, would you? And two, have a better policy on all of these issues. So I would say this is the biggest take-home slide for you of if you wanted to be involved in the process beyond being informed.
Jared, are you saying that they would negate our going beyond what they proposed, the DNR?
I'm saying that DNR looked at the draft 03214, I'm sorry, yeah, 03214, and no, I take it back. So I talked about the different, I haven't talked about the different versions yet, but I gave them, through our city attorney, Mike Leahy, the draft that I was endorsing. And that draft had no net loss in it. And DNR said, you can't have this, if I would like to say that. So yes, I would say that's negating. No, that's a big deal, right? We got to work on that.
We're going to test them.
Yes. So yeah, I think I talked about everything. So on this page. So let me talk a little bit about the versions. I want to try to go through this fast enough that I don't get bogged down on sort of tangential details, but informative enough that when these terms come up and we talk about them, you're informed. So start with the Model Act. In 1992, the state passes this law. It then sends this to DNR, and DNR says, local jurisdiction, here's the model ordinance. And this is common for state legislation like this, where DNR says, here's the floor act. If you pass this, we'll approve it. Or if you want to work from something, this is what we think is a good template. Go out working on it. So when we refer to the, I wrote model act or model ordinance is really the better term I should have written. That's what we're talking about. The Forest Conservation Act Working Group I mentioned from 2012 started from the model ordinance and then worked on suggested changes. That's the version that was legislation but expired with Josh's term. 03214 is where I picked up from the working group, and I say I, and I really shouldn't because I had, I did not do the heavy lifting on this. I had a lot of help. But 03214 was, let's take the working group act and improve the standards and see how much better we could be, involve a lot of how we want to be very transparent, so we want everything posted, we want to make sure things are fact-based, so it had the concept of the city environmentalist, which is basically someone that's already exists. I wanted that person to be able to be the fact checker for the delineation, the inventory, rather than have potentially a policymaker, a politician, or someone appointed by a politician be the approval of that. That was rejected by most of my colleagues, frankly. So I knew that wasn't going to go very far. So legislation that involves the Planning Commission like this goes to the Planning Commission for advice. And so 03214 went to the Planning Commission for their advice. And they took it up, basically said, you got good bones here. We like this, but there's certain things, like what I just mentioned, that weren't going to fly. Let us, Planning Commission, help you draft something that we think, as a Planning Commission, that we really like. Surprise, surprise, that version had everything going through the Planning Commission. They wanted their hands on it. Fortunately, that didn't create too much of a fuss. The Building Board of Appeals, I'm paraphrasing, but basically they said, if that's the way you want to go, that's fine. So they weren't heartbroken over losing some step in that process. Then that Planning Commission version, which I then put my support behind because I felt like that was something we could get 5 votes on, went to DNR, and that's when DNR came back and said, nuh-uh, and they threw a little wrench in the plans. As we were talking about how to go from there, Alderwoman Finlayson then filed 02715, which is pretty much based on the Model Act, just trying to address some of the very specific codes. So it's basically the floor standards, but suited for trying to adjust for the city, the format. At that point, essentially, before I go on to the next page, the people who have been the most outspoken on the council about this legislation have been trying to get together, and I think a very positive, collaborative way. And so that's Ross Arnett, it's Sheila Finlayson, Joe Budge from Ward 1, and so the 4 of us have been meeting, continue to meet, we meet again tomorrow afternoon, and these are really fun, exciting meetings, let me tell you. We fortunately have had some guidance away, but these are just very tedious meetings. Like I said, this legislation with footnotes and showing changes, we're on 60 pages. And so we're working, I'd say, our hardest at it. I think we have a chance at good collaboration where we have, I couldn't say for sure that we're going to reach agreement, but I would say that we have hopes of reaching an agreement. I don't know what, I don't think either of us have yet said what our pressure points are of what we absolutely have to have. What I'm hoping for is that we have some consensus of an agreement where even if it's not unanimous, we have some consensus that then could be offered as a wholesale amendment to O3214 that basically has the support of the four of us. And basically, and I hope I'm not overstepping my guidance, but I think if Ross and I, Joe Budge, and Sheila all say we support this, we're going to have pretty widespread support on the council. What I would envision is there might be an issue or two that we don't have collaboration on, that whoever doesn't agree with what the consensus was will offer an amendment to that, with that new document. That new document, of course, is going to be substantial, a substantial change, and so there'll be a new set of public hearings. So, with bold, highlight, italics, theoretical, not in stone, so don't hold me or anyone to these deadlines, in thinking how this could happen, this is what I'm expecting. Ongoing meetings with city colleagues. I am hopeful by the time of our next city council meeting, which isn't until July 13th, but I'm sure will come very quickly, that we'll be at a point where the four of us can offer an amendment to O3214 and offer this new amendment with the four of us as sponsors to replace in whole O3214. When something that major is done, you're not changing a line here or there, you're changing. Most likely the city council is all probably going to agree that we need to have a new public hearing. If that happened at its earliest point, which is a huge if, that would happen at the next council meeting, which is July 27th. The council at least, goes into recess in August. When we come back, the next step after a public hearing is committee review. I don't think we would have to send this back to the Planning Commission because they were so involved in this whole process, but they might want to have a say. I'd be surprised, frankly, but it's possible. The committees certainly be environmental matters. Frankly, there's probably 3 or 4 other committees that this goes to, rules, and I don't try to memorize that sort of thing. But there would be various committees. Because committees don't meet in the first week of September, we meet throughout the month. The earliest we could have a vote on is the second meeting in September. And that's why I say possibly September 21st. And so that's really, frankly, I think best case scenario. We're still waiting until September. And that's where, my page got cut off again, but that's on this page it doesn't really matter. The other important point to add, going back to DNR, whatever we approve still has to get approved by, whatever we vote on, I should say, has to get approved by DNR. I would anticipate getting sort of a pre-approval, and I wouldn't ask the council to vote on something that I didn't think DNR was going to approve. That wouldn't be wise. And then my last line got cut off is lots of hurry and wait. I mean, we go through these periods like right now where we're all working really hard trying to get a draft that the four of us agree on that we could present to the full council, and then we're going to have to wait for a couple weeks, maybe for a public hearing. And then we're going to have to wait for August recess. So it's a lot. This is how this whole process has been, I guess. Welcome to legislation. So, finally, on my summary page, I hope I've made some of these points, and if not, I'd like to emphasize them now. FCA is not about stopping projects. It's about balancing tree conservation, development, fairness, and predictability. The FCA operates by requiring a natural resources identification, saving priority areas, and of course you got to define what your priority areas are going to be, and then having some sort of mitigation. Change is needed in my eyes and many others so that we add structure, we improve the standards, we have a transparent process, we have a process that involves the public at meaningful times in a meaningful way. The current FCA projects certainly demonstrate that this is important legislation. All these projects that we talked about, I think we'll probably have a consensus, at least in this room, that these are pretty major projects that impact Annapolis significantly, and we want good legislation to be guiding these developments. I think it's easy to say we want legislation to apply retroactively, and after this, there's going to be no forest left, so what's it matter? But I think the reality is any legislation starts with that mindset, and there's always something else, like this annexation down by Georgetown Road. Who knows what's going to happen in the future? So, although it's frustrating in my mind to think that we couldn't have had good legislation passed 5-10 years ago before these current developments, I try to look prospectively and not get hung up on that point. The council needs to resolve these issues, and I laid out what I think are the important issues. If you ask Ross or some of the others, they might have other issues that they would list as the important ones to resolve. A big part of this also is just education. Like I said, the four of us have been working on these issues. I think the four of us are pretty comfortable with the issues, but I don't think I'm going to be offensive saying that I don't think all my colleagues are as familiar with these issues as I am. And so to get to be able to have that education and understanding to get my colleagues to vote for this, I think is going to be a huge hurdle, even if they're not coming at it from an argumentative standpoint. This is going to be much tougher to educate someone on than most of our typical legislation. And then my last point, which is cut off, new draft, public hearing, review, and vote. I laid out the process. So it is a time-consuming process, but I think we're on a path to completion. We'll see, I hope. So with that, that's my presentation. I hope it was useful without being droning.
Yes.
From the overall view, like, taking a bird's eye view of this, I don't know this, but, we have 100 trees in Ward 5. Is the basic idea just trying to reduce the loss of trees, just generally? And then, what's acceptable? Like, should we go down to one, like, if everybody has their own little parcel and we all want to cut out 50 trees on every lot, let's forget the 100 thing, but say we want to cut out 50% of our trees, what's an acceptable minimum? I mean, has anybody pinpointed that? And also, how do we identify important areas where trees are? Can we use GIS and satellite imagery to identify areas where there's great slope and great runoff? It seems like there's some solutions.
So I'm going to try to answer your questions, but you had a lot of compound questions in there, so if I don't catch them, come back to me. So first, I'm going backwards. The GIS issue. GIS is useful for tree canopy. So we have it in Annapolis, a stated goal of 50% tree canopy. We're at, the original measure was 42. It's been revised to be 46%. You have to remember that in that intervening time, Crystal Spring property was annexed into the property, so of course added trees without actually showing production improvement. Regardless, we're still below 50%. So in my mind, if you're at 46 and you're trying to get to 50, and you allow each development to cut half their trees, you're obviously mathematically, you're never going to have more. And so that's where I'm trying to say, let's at least work on getting no net loss. Let's reach no net loss and then look for opportunities to improve. So GIS I don't think is terribly important for slopes. I think the slopes and soils and streams, that's more of on-site inspection. And that's where the developer is charged with having a proper analysis of what's there. What I suggested in this legislation, and I don't know if it's going to fly with my colleagues, is if the developer goes twice to produce an inventory, turns in an inventory, and the city says, no, you missed the stream, you missed this tree, then after the second time, the city gets the right to say, we're going to farm this out, just like they do with traffic studies, at your cost to just get an independent inventory. It's supposed to be fact-based. It shouldn't take 8 tries to get an inventory correct. So, like I said, I don't know if that's going to fly or not. It's part of the legislation that I'm trying to get in there. So what else? Soils, steep slopes. I didn't get into those details, but yes, one of the issues is going to be how steep of a slope is it can be considered steep and therefore need some extra priority of protection. That's also one of the issues that I didn't highlight, but that's among the issues that I'll need to work with my colleagues. 15% or 25 are the two numbers we're talking about. Come back to me with your questions. I know I didn't get them all.
I want to say great job, but
Thank
just
you.
like, what is enough? You know, like we have, like when I walk into Trump,
Oh, yeah,
I get
okay.
a great feeling. It's like psychological value. That woman mentioned so many values, you know, aesthetic, but just the feeling of like, oh my God, there's something more than just even aesthetics. It's just this feeling. But that is my question.
So part of the confusion is that this act is not the only legislation in the city code that affects trees.
Right.
So the city has other parts of the code that's more designed for the individual tree issue. And so if you're talking about an individual tree on your property that you want to do something with, you're not going to be looking at Forest Conservation Act. You're going to be looking at, I don't know how else to refer to it, but Title 17.
Right.
That's where more of a DNIPS, individual tree, residential tree. So the idea is that this is meant to be bigger parcels, but like I said, 40,000 isn't all that big. And it's supposed to be that sort of baseline and getting better. As far as what's important, that's partly up to the city council right now, and what they're going to say is priority and deserving protection. We talked about different sizes of trees, and there's different ways to describe important trees, but that's what we're working on right now. And so I think the city council acts best when it has a lot of public input. Not to make the comparison to the budget, but when you have a big budget document and very little public input, other than people saying they don't want their taxes raised and they don't want services cut, that's not all that helpful, frankly. But we have specific input, and a lot of that input then I think the council is more likely to move, and that's probably not speaking specific about Annapolis City Council. It's any government jurisdiction can be like that. You know, so okay.
I've got two questions, but one is a legal question. So I realize that the city is kind of like a creature of the state, right? So if an ordinance is passed that DNR doesn't like, what does that mean?
So this is still operated by DNR. So DNR could say one of many things. They could say you don't approve that, and therefore it's invalid, and you operate under the status quo. They could say we're going to take over your program, although I don't think anyone would envision that happening. But more likely it's the first scenario. Go back to the drawing board. Your ordinance is not effective.
So essentially, the city is bound by what DNR
Yes.
says on this.
Yep.
Okay,
Yep.
my second question is, I don't know if this is true, but there's a story going around that DNEP is going to be divided and absorbed partly by planning and zoning and partly by code enforcement.
So no, I don't know what's going to come out of the administration.
We don't know whether it's true or not.
Yes, yeah. Yes, that has been discussed. Yes, I do not know what's going to happen with that. It's, I don't think it drastically changes anything, frankly, other than the way this legislation, the one that Ross and I most recently have been working on, envisions that the Forest Conservation Plan and all those pieces get filed with Planning and Zoning. And then Planning and Zoning farms out this environmental stuff to DNEP. And so it works under the current scenario where there's DNEP and Planning and Zoning. It also would work quite easily if they were merged together.
So planning and zoning is still driving the car, essentially.
Yes, yes. And it's presumed that they will give discretion to DNEP, or if there's not a DNEP, but whoever's responsible for that program on the technical environmental issues. Planning and Zoning will concentrate on its bailiwick of the planning side of things. Earl, I think you'd agree with things.
Yeah, besides the acreage requirements that they have in the, it seems to me, as I read the article, there's also additional requirement above and beyond that in protecting priority areas for preservation. Which are not to be disturbed unless they would adversely affect the property. However, just pure economics is not supposed to be the case. It's, the DNR referred to there's two sort of separate requirements, one of which is if you clear more than 20%, you have to plant 5 acres. And then also, but in addition, you have to protect these priority areas for protection, including contiguous forests, and you have to make the case that if you're going to disturb that, you'll have a damn good reason for doing so.
I think you're talking about the variance provisions.
No, I'm not. I'm talking about the first section in the paper
The
that
justification.
says priority areas. The following are priority areas for protections: areas on steep slopes, areas that wetlands, and areas designated as contiguous forests. And in that, it says that these are not supposed, regardless of the total acreage requirement to be retained, these are in addition supposed to be retained.
The way the legislation, the way that the model ordinance and what exists today basically has a lot of discretion in those areas. It's not as definite as you described it.
The discretion is what factors you take into account in determining whether a project cannot be adversely protected. But you have to address that as a separate item above and beyond just, if you preserve more than 20%.
I hear what you're saying about there being responsibility to go above and beyond the thresholds. And what I'm saying is that the model ordinance and the status quo is not nearly that definite.
Yes, it is.
Okay.
Well, I would like to talk to you further about that because this seems to be really the key in deciding about this is that you want to make sure not only that a certain acreage of trees are forested, but your prime value forested areas are protected as well.
Do you want to answer this?
And
Yeah,
I think that that's...
I hear what you're saying.
The way it's done typically under the model ordinance and in a lot of other jurisdictions is that it'll say define what's a priority retention area. and then it'll say, conserve all of this area unless the applicant demonstrates to the department that they have really good reasons to remove some. And then there's usually 2 levels of that discretion. The lower level is priority retention areas, and then there's a variance requirement that usually will account for endangered trees and others. So there's kind of 2 priority levels. They're both discretionary. Variances have a little bit more criteria
Well, the first
behind
one
them.
is not, the endangered species is not discretionary as I read it.
They can be removed under variance criteria.
Your lane,
Lutz, Chesapeake Bay Foundation.
your last name is Les?
Lutz, L-U-T-Z. Yeah, so I mean,
Because I'd like to get some further guidance on that, because you seem to imply more flexibility of ignoring the law's basic requirements than
I mean,
have seen in what Anne Arundel County and some other counties have done. The 2 other points is, one of which,
So don't leave that one though, because that's kind of the basis of why we're here. I mean,
Right.
the basis has been that the tradition amongst the staff has been to not exercise all of the powers and authority they have. And so those kinds of things don't get challenged, and we don't get, and yet, I don't think we've yet seen any justification written by the developers for any of the things they're doing in the areas that you're talking about, Earl. And that's what stimulated us to get, and we have to give Jared huge credit for the lion's share of the work here and sticking with it, because God, it is awful. It really is. But that's why, and that was why the initial inclination in the thing was to be very prescriptive in the original 3214. You have to do this, you have to do this, you have to do that, and not allow the discretion. And we'll see where we end up in the final product.
I and I assume a number of others will be very interested in watching what you do. And we agree that this is one of the key items in the bill, is how much discretion the city wants to have, whether we want to be high-nosed or more aggressive. The other thing that I find interesting is the state now has a state law that throughout the entire state, there's supposed to be no that law supports.
It's not a law, it's a stated policy.
No, that's state law.
There's a law, but it's just
There is a law.
incentives. It's not really prescriptive. It just gives.
How you do it is not.
The articles I've seen about it refer to it as a state policy.
It's a law that got passed.
well, it's in the code,
They
but
just
it's
give
a
incentives.
stated policy in the code. I mean, it's at the beginning of Natural Resources article. The law was passed in 2013, my first session, and we worked on that bill, and it says, you know, it is the policy of the state to achieve no net loss by 2020, I think it is.
But it
So
doesn't-
it's
yeah,
to,
it just
it's a
gives
policy
incentives
to
locals
achieve,
plant
it gives some
trees
lip
and all
service
that.
to the state should encourage locals to,
Doesn't have any teeth.
no.
Well, it has as much teeth as you want to give it.
Oh, I did have a question. From the projects that you showed that were in the pipeline or starting to, wanting to get annexed, which ones of these, which stages are they in that this, your new Forest Conservation Act would apply to? I mean,
Good question.
is it just the application for the forest stand delineation? Is it approved and then they're out of this and
Great.
they don't have to apply for new law because
I'll answer the first question first, and then answer the second question. Right.
resolved under the broken law and
So this property, Annapolis Neck, they are not annexed yet. So they've been asking essentially for preliminary input from the city on if we were to be annexed and file this, what would you say? And so nothing that the city could say at this point would be sort of held, be bound by, because they're not even city property yet. So that's very preliminary. But to answer your underlying question is, what is the effect of this legislation? And that is, of course, it's no surprise, one of the issues were yet to be determined. As we've written it, it's effective on the effective date for any application that has not yet been approved. So on a project that would have, say hypothetically, a forest stand delineation approved and a forest conservation plan approved, but not a grading permit, they would not have to go back and do their plan, redo their plan. But if they have just the forest stand delineation approved, but not an approved conservation plan, the conservation plan would have to comply. But that is definitely not
Whatever
definitive.
stage they're in that hasn't told, that hasn't
Can
been
you go back a
approved,
slide?
then
Yes.
that-
Can you go back a
that
slide?
can tell us where they stand.
So Crystal Spring, which I imagine that you were curious on where they're at, they've done the forest stand delineation, have not done it, they've not gotten an approved forest conservation plan. So if this legislation passed today, which we already saw, that's not going to happen until September, if it got a legislation passed and DNR approved it, I should add, before their conservation plan was filed, then it would apply. And I should have said, if they filed, it's hard to be definitive because this is nothing set in stone. You know, I might have a different answer in 24 hours from now after we have our next meeting, and so then I might have a different answer when we the four of us go to the rest of our colleagues. But all of that is definitely at play, and so I would just chalk this up to that list of issues if they're important to you, that you make it clear to your elected officials that you want what kind of effective date application you want to apply. Do you want this to apply to anything that hasn't yet been filed? Do you want this to apply to anything that hasn't been approved? Do you want to give them 60 days after the legislation so they can quickly file anything that they've been working on? So all that is in play. I don't have a definitive answer for you.
Any appetite for moratorium on approval until we
No.
get this straightened out?
No, there's not.
Why not?
Could we maybe have a show of hands of those in the audience who would like the effective date to be applies to anything before that stage has been approved?
I think you'd be hard pressed, no matter 100% of people raise their hands to that question.
Right.
You're not going to get more than 2 votes for any sort of moratorium, and you'd struggle to get those 2 votes because I think even Ross and I would need to see the legal basis, and we've gotten legal advice that that legal basis does not exist. And even if you convince us otherwise, you're not going to get more than 2 votes for that.
But isn't it important that here you have your constituents, and most of these constituents in your group and also the county and Ward 4 and Ward 5, we're not here because we want excuses as to why you can't protect the land. We don't want your bureaucrats telling us numbers and this and that and the other. What I would like to know, and I think most people here would, we're not here because we want to protect the development's interest in this. It's called the Forest Conservation Act. Forest conservation. It's not to give it, but unfortunately, like most regulations, they're meant to keep the environmentalists down. The regulations are only for us to sort of, oh, we went through it. We passed a law. We cut down an entire forest. Let's not fool ourselves. This is for one thing only. We have one giant forest left in Annapolis, and it wasn't part of Annapolis until developers decided that that was the best way to get it developed because the county would not let it happen. So now we've got one great forest, over 100 acres, 2 farms, over 300 acres of open space, never been developed. And I want to know, what is your guiding principle as our representatives? What's your ethic? What is your land ethic? What's guiding you in making this decision on informing the public about how the Forest Conservation Act is going to work to their benefit when it's going to cut down all the rest of the trees in Annapolis, really? We're talking about minor issues here, I think. What is your land ethic? And I'd like to hear from Ross Arnett, too, and any other public officials in here, as to, we don't need more laws, we need a land ethic. Is it immoral to cut down this amount of trees in our city?
So, 2 responses. First is...
I have to go now.
What is your land ethic? That's what I want to hear.
Yeah, so 2 responses. First, my responsibility is to follow the law. And so I'm not going to propose legislation that violates the law. And when I have a city attorney who is our arbiter of what is legal, what's not, saying you don't have due process, you don't have authority to have a moratorium, regardless of how important I think, how good of a purpose I think it serves, I don't have a law to propose. Second, I'll go back to what I said with the budget. If this is a city of 38,000 people, probably half of that is adults, let's say. If we had 15,000 people write to our mayor and our city alderman, I bet there'd be a way around that and figure it out. But there is not a groundswell of support for a moratorium. There's just
I'm
not.
not talking about a moratorium, I'm just talking about your ethic towards land. What is it?
I don't think that's there's no set ethic. I don't have a 5-word soundbite to give you that's an
How
ethic
do you
towards
not have
land.
an ethic about how you determine decisions?
I don't have a 5-word answer for you. I could sit down with you for an hour and talk to you about the issues that are important.
Okay, so there's no moral issue here.
That's not what I said.
No.
He's trying to improve this act.
Right.
He's the only one who's taken this initiative.
Well, no, let's give Ross a lot of credit. He's been through hours and hours of this. He's been awfully kind to say that I'm taking the lion's share, but he's been through most of this stuff with me. He's done just as much hard work as I have.
Bravo.
But the ethic, first of all, we wouldn't be doing this. This isn't a lot of fun if we didn't believe in the fact that we want to conserve as much as we can. And there's a lot that we personally are not very happy about. But as you well know from your experience in legislature, 1, 2, 3, 4, 5. It's how many votes you can get to get anything through. And we are, and we'll be again tomorrow afternoon at 1 o'clock, in a process of trying to get as much of the 03214 done as we can. But we've got to get 5 votes. If we don't get 5 votes, we'll be right back where we were in 1992, which is we will have nobody following any rules whatsoever. It's kind of ironic. The DNAP was created in 1990, right around the time this act was done. And so we have these huge roadblocks because we split it all off. So Title 17, Title 21, it's a mess. And then we had the politicians involved in this too. The message to DNAP staff was, we want annexation and we want development. And that's your job. We, the elected officials at the time, want those things. And that's why they turn a blind eye to some of these things. And that's why we're in the mess we're in. And I don't think anyone, in fact, I fought this Hayes annexation. I voted against it. But I don't think anybody on the council, and none of the current members on the council have been there for any annexation other than the Hayes, had any inkling of what the game was. The game is bait and switch. The game is 25 farmettes, and all of a sudden you have the big commercial development and townhouse and everything else. Nobody had any idea that that was coming our way. We should have. I mean, and again, we weren't there, but I think we have been just as naive about some of these things as our predecessors were. It is a game where the power is not in our hands, it's not in your hands. It's in the hands of dollars. And, to look at this any other way is to be as naive as we have been.
Sounds American.
Pardon?
Sounds American.
It sounds un-American to me, but...
Yeah.
Kurt, before you start, don't you all have something coming up in August? No, Seven River.
Our president.
I didn't see it. Okay.
No, that's Seven Rivers. That's a people.
No, the cruise.
No, that's the Seven
No,
Rivers.
that's something else.
Separate.
No, not related.
Apologize.
All right.
I got you. I know.
Um,
Thank you.
I'm very disappointed to learn that there is a policy difference between the state and the city on an interpretation of the Forest Conservation Act. Policy differences are one thing, and you wonder if they're being driven politically. I spoke to the former head of DNR, John Griffin, and to him, the former head of DNR, it's very clear that the city of Annapolis has latitude to make its requirements more stringent than those that are set by the state code. So where is this difference coming from? And how do we arbitrate it? What levers does the city have to bring DNR around to a point of view that indeed we can make our requirements more stringent than those minimum requirements in the state law?
Thank you.
My answer to that is, I'm urging that we brazen it out as much as possible. Now, they're bureaucrats just like all the rest of the bureaucrats, and they don't want to make waves, and they don't want to fight. And I think we should ask for everything that we're pushing for in terms of like the no net loss. And in fact, our city attorney has kind of made a big 180 and is starting to help us figure out ways that we can get no net loss in there and maybe make it palatable. But I have a feeling that if we say, you know, this is what we really want, and, you know, if you deny it, then go ahead, take over the program. You know, they don't have the resources to do that. And so I've been an advocate of, let's ask for as much as we can possibly get 5 votes for on the council and make them say no to us. And then I think we go to our representatives. We have some friendlies.
Yes.
We can go to-
No, wait.
Pardon?
Now.
Yeah, well, we can't presume that they're saying no to us. We have to go through the steps.
Rob, could we not go to the Attorney General now and ask for
Yeah.
opinion?
Yeah, it's already at the Attorney General.
Oh, it's already there?
Oh, yeah.
Where is it
But
now?
not in a good way.
Okay.
It's been the Attorney General has been part of the pressure on DNR. DNR is in an embarrassing position because they've let us not enforce things for a long time. And so now they're trying to scramble to cover their tail. And the Attorney General, the Assistant Attorney General, is looking at this, and again, because it was sent to him, to them. It's a woman who's working on, right, the deputy.
Sheriff Albert, yeah. Expect a legal
By our
interpretation
city
next
attorney.
week.
So we've got them looking at it at the same time DNR. So DNR now has them looking over their shoulder. So they're kind of between a rock and a hard place. Right.
Yes, is there any other jurisdiction in the state that has applied this already, the no net loss provision to their forest?
No, we would be at the forefront of that. Most jurisdictions have a Forest Conservation Act, and they do not just say, we adopt the state code like Annapolis did. But no, there's no net losses. Every jurisdiction.
What about the county?
They do not have no net loss, if that's what you're asking, but the county does have a Forest Conservation Act.
Separate from the model act.
It's based on the model act, isn't it? Pretty
Yeah.
similar to it.
Jared, you indicated earlier, though, that there are many other facets of the no net loss that seems to be you're allowed to exceed, except for this particular one.
So they said, the argument that was made to me, not the argument as much as just sorry, this is what you've got to deal with, that was made to me was, this chart was the result of compromise on state law, and so this is the parameters of how the state, the legislature is intended to be. And I was told that if you look at their legislative history, they intended this chart to be immutable.
And that was by a legal representative?
This was by the person responsible from DNR with implementing the program.
But
You didn't go through our attorney?
No,
a room full of lawyers.
Yeah, there's a room full of lawyers, including Ross and I. Yeah.
I'm not a lawyer.
Rick?
Yeah, over and over again, the Annapolis Environmental Commission has pointed out to DNAP this whole thing about priority for retention unless the developer has shown why he's looked at all our alternatives, doesn't find any, and he must have, 500 houses versus 200, whatever. His I must have it. Where we need sunshine is what are these things that the developer is saying he has to have in order to make any profit at all on his property. I've never seen anything in writing.
So in the Plymire report, after the phase one of the issues I came back with was essentially this issue. Had the developers on these projects, and I came up with, I forget the 4 or 5 that I thought were the most pressing, have a justification stated. And in the Plymire report, he says he went through and he found justification. Now the issue is, was it sufficient? And that's where DNEP has a lot of discretion. I think if you got a flavor from DNEP, and I won't say if you ask them their opinion, but essentially what they would express is they were looking for guidance from the council. If the council wants DNEP to have a stronger opinion, the council should pass the law or make some stated policy. But the council has not gotten its act together, or not, I shouldn't say it that way. The council has not spoken in unison on these issues. There have not been 5 council members that said, we want you, DNEP, to interpret this the most strict way possible.
Okay. The Annapolis Environmental Commission is required by code to advise DNEP and the other organizations in the city. over and over, we have pointed out things why whatever the developer is planning is not justification in our view. Never once in 5 years, since 2011 that I've been on that Annapolis Environmental Commission, not once has DNEP sat down with us and said, oh, okay, this is your point, and here's our counterpoint, and we discuss this. Never once. We give the information, we give experts from outside. We give that to DNEP, they make a decision, they never get back to us. I have no idea what their decision process is.
It's frustrating. I don't have a better response other than I understand your
Well,
frustration.
wait a minute, first of all, does inconvenient truth ring a bell here? But one of the things that, the reason I'm invested in this is, I just think it's outrageous to not have, early in the game, the public have the very right that you're talking about. And so the way I would have it go, if